Court is now in session.
Myself and Associate Chief Justice Ballard will now deliver the verdict on the pretrial motion. Taking into consideration what was previously stated by the lead defense and lead prosecution, the tribunal has come to the conclusion that we will proceed with the trials. Defense believes that the trial should not take place as the charges should not be considered crimes. However, there were several treaties and written legislation that was already established before the war, which Germany did break. So we do agree that the trial should happen. Additionally, the defense claims that the Allies have committed similar actions that German people are being charged with. However, this is fully not the case, and like prosecution stated, for example, in the Korematsu versus United States case, the United States excluded Japanese Americans from society, which they do understand is very morally wrong and is unjust. But like prosecution stated, they are both unjust, but the actions that the United States did versus the actions that Germany did are by no means comparable.
The defense also argues that it is unfair to let the winners of the war decide the fate of the losers. However, this was the only possible practical mode to carry out these trials, and these regulations were agreed by 22 different nations, and we need to set a precedent somehow. The defense also argued that the acts of the Third Reich was made for the benefit of the German people. However, there were several marginalized groups that were also German citizens that were persecuted by the Third Reich. So this is obviously not valid.
The defendants argue that the trial should not take place as it is victor's justice. However, this can directly be confirmed to be false, as the suspected unfairness targeted towards the defense can be confirmed false in Article 16 of the Charter of the International Military Tribunal, which explains how, first off, the indictment shall include full particulars specifying in detail the charges against the defendants. A copy of the indictment and all of the documents lodged with the indictment shall be furnished to the defendant at reasonable time before the trial. Furthermore, during any preliminary examination or trial of the defendant, he will have the right to give any explanation relevant to charges made against him. Defendant's preliminary examinations may be submitted as evidence. Furthermore, a defendant shall have the right to conduct his own defense before the tribunal or to have the assistance of counsel. And lastly, a defendant shall have the right through himself or through his counsel to present evidence at the trial in support of his defense.
And we agreed with the prosecution that even though every nation has the privilege to rule over itself and its people, these circumstances are cause for the global community to step in, as the destruction of humanity has never before been as organized or powerful as it has been throughout the Holocaust and World War II. Taking into consideration all of these measures, we decided that the only possible measure is to continue with the trial.
Before the case against Goering, Justice Box will clarify the charges against Dönitz.
As said in the opening, tribunal regarding count 4 crimes against humanity, defendants Karl, Dönitz, and Franz von Papen, the charge will be dropped for crimes against humanity.
The court will now adjourn until 12:45.
Hi, everyone who's in here right now. This is your little chance to get to see behind the scenes as you normally would between cases. Ms. Dorr, I figured it was easier just for us to talk for a minute. We can always edit this out for the final video. Do we want to wait 5 more minutes until we get started?
My concern is just that if anybody was coming just for the Goering case, including parents, if we start early, they'll miss some of it.
Okay, sounds good.
So that's the reason for usually not going ahead of schedule.
Well, we only have 4 more minutes. So again, everybody hang out. Any panelists, if you need to ask any questions, just use the Just a Panelist chat, and we'll get started in another 4 minutes.
3, 2, 1, right?
Yeah, right.
Court is now in session.
We will now hear the case of IMT versus Hermann Goering, and the prosecution can start their opening.
I come to this court as a human being before anything else, and I ask everyone here to recognize the connection and undeniable rights that we all share as humans, rights that the defendant Hermann Goering irrefutably denied to millions of innocent people, and he did so through meticulous planning. Our job today is to convince the court that the defendant Hermann Goering is undoubtedly guilty of conspiring to commit crimes against peace, war crimes, and crimes against humanity, and also guilty of engaging in those crimes. And I believe that we'll accomplish this goal, for the copious amounts of evidence against him are so damning it hardly needs any explanation. The court has been provided with numerous documents that prove his fault in these significant charges against him, some being orders that Goering issued himself that demonstrate the lengths he went to in order to try and secure the Nazi Party's success before and during the war, a war that, if it was not for Goering, would never have even taken place. Hermann Goering, in the multiple roles that he held throughout his time as a Nazi Party member, is responsible for preparing for and waging aggressive war on non-combative countries. On the charge of conspiracy, Goering joined the Nazi Party in 1922 and was a continuous influence on the conspiracy up until his arrest in 1945. I can assure this since Goering was the man who ordered, in writing, for a solution to the Jewish question in 1941. It is clear that Goering influenced the direction of the conspiracy early on and had a hand in every stage of the conspiracy from its inception. At the very beginning of those 2 decades of allegiance, Goering gained Hitler's trust. Because of this, he repeatedly moved up the ranks into more and more authoritative positions. With each new position, Goering continually earned more responsibility over large organizations within the Nazi Party, and with that, more control over the conspiracy. He began as Prussian Prime Minister and Prussian Minister of the Interior. In this capacity, Goering promptly took control over the already existing Prussian police and established the secret state police in the first concentration camps. Goering created the secret state police, also known as the Gestapo, for the purpose of eliminating any threats to the Nazi Party by using whatever means necessary. It could be argued that Goering just gave the orders to the secret state police and that he never actually participated in any of the violence, when in reality, he proudly, even boastfully, took responsibility for the vicious actions of the secret state police in a speech he gave before thousands of Germans. He stated outright that each bullet which leaves the barrel of a police pistol now is my bullet. If one calls this murder, then I have murdered. I ordered all of this, I back it up, I assume the responsibility, and I am not afraid to do so. And that quote is from document 2324 PS. Goering was also a member of 2 exclusive councils established by Hitler and was present at multiple secret conferences regarding the direction and initiation of war in his capacities as plenipotentiary of the 4-year plan and Commander-in-Chief of the Air Force, in which I maintain are the 2 positions that Goering did the most damage in. It was Goering's job as plenipotentiary of the 4-year plan to prepare the German economy for aggressive war, and I can confirm this as he reiterated it himself when he stated that he believes it is his task to, within 4 years, to put the entire economy in a state of readiness for war. And that quote is from document EC 408. Goering was granted far-reaching and exclusive control over the entire German economy before the war. Yet his duties as plenipotentiary of the 4-year plan didn't end when the war began, as he then gained control over all of the occupied territories' economies, and with that, control over the people in them. This brings me on to Goering's accountability for crimes against peace. Goering was named the highest-ranking official in the Air Force on May 5, 1933. And allow me to remind the court that due to the Treaty of Versailles and its provisions, any position relating to the Air Force was completely illegal for anyone to hold in Germany. The Treaty of Versailles prohibited Germany completely from having an Air Force, meaning that from 1933 to 1945, Goering was in direct violation of the treaty. In a speech to the German people on March 16, 1935, Hitler justified the rearmament of the German military and restoration of the German Air Force by saying that it was solely for the protection of the Reich. However, Goering contradicted that promise in a speech he gave. Goering said, and I quote, "I intend to create a Luftwaffe which, if the hour should strike, shall burst upon the foe like a chorus of revenge. The enemy must have a feeling of being lost already before even having fought." And that quote can be found under document 3441 PS. In this speech, Goering made it clear that it was his intention to build a hostile, war-ready Air Force, and he was successful in this endeavor, as he was also in command of the Air Force throughout the war. There is one distinction that is important that I make clear, and one that I hope this court will remember. Goering was given control over multiple organizations that were vital in bringing the Nazis to power and the extreme destruction caused during the war. Every order given to the secret state police and the Air Force, and every decision made in the interest of the German economy, were under jurisdiction that Goering controlled. As I have established before, Goering was a very high-ranking officer, and not only that, he was Hitler's second in command. Hermann Goering was not taking orders from anyone. Hermann Goering is a smart man and knew better than to get his hands dirty. Rather, what he was able to do was far worse than any Nazi soldier. He stayed personally out of danger and used every power that he was granted to its full capacity to inflict as much damage as possible. Goering designed the crimes that he forced his inferiors to commit, and this makes him unquestionably guilty of conspiring to commit crimes against peace, war crimes, and crimes against humanity. But staying above the dirty work does not guarantee that he cannot be found guilty of being engaged in committing these crimes. Since Goering also held a commanding position in both preparing for aggressive war and conducting it, he is also guilty of crimes against peace. And as my co-counsel will argue, he is also at fault for committing war crimes and crimes against humanity.
Your Honor, Hermann Goering played a profound role in the murdering of 6 million Jews. Not only was he present in many decision-making meetings, but he was responsible for the creation of concentration camps, the final solution, cutting off all resources in other European countries, and even in document 2324-PS, Goering confesses by saying, "I have murdered. I have ordered all of this. I back it up. I assume the responsibility, and I am not afraid to do so." In preparation for the war, in document 3441-PS, he says, "I intend to create a Luftwaffe, which, if the hour should strike, shall burst upon the foe like a chorus of revenge. The enemy must have the feeling of being lost already before even having fought." What many may not understand is through Germany breaking the Treaty of Versailles, the country was ending the peace that the other countries had the courtesy of providing them to prevent them from entering a depression with no escape. Through his role as leader of the German Air Force, he not only committed these horrid crimes, but attempted to justify his reasoning and brainwash Germany with his false facts. His logic claimed to be solely helping and providing for the sovereignty of his country, but in reality, it was acquiring total control. He joined the Nazi Party in 1922, and from that point on, his deliberate actions didn't stop. He used the propaganda that he inflicted on Germany, and through the escalation he had towards the hatred of Jews. He begins to justify his cruel actions, but while some may see it as a man who isn't afraid to confess what he did, others recognize the brutality of his murderous ways. So in his conviction of war crimes and crimes against humanity, you must think of documents EC-317, where he cuts off resources in other European countries that Germany had annihilated. When he escalated the war beginning in document 1412-PS, fining Jews for being Jewish, to eventually send them to concentration camps. In document 1956-PS, it establishes that Goering created the secret state police and the roles the SS had. It explains the roles of the secret state police and in which the creation of concentration camp. It is no secret what happened in these locations. They were used for nothing other than the explicit murdering of humans. Goering sent women, children, and the elderly to be gassed. Outside of these camps, Jews were forced into ghettos, all for the convenience to have them forced out of their homes to be shot. As plenipotentiary of the 4-year plan, he was responsible for the war. After assuming this role, there is no justification that he didn't want this to be a bloody massacre. Even once Germany realized their loss, they continued exiling Jews. In document 710-PS, Goering writes a letter to Heydrich explaining for him to organize how they will take all the Jews to concentration camps to be murdered. Among the bloodiest massacres was that which occurred at Babi Yar, just outside Kiev, Ukraine, in late September 1941. There were close to 34,000 Jewish men, women, and children murdered over the course of 2 days. And one mustn't forget the extermination camps in Poland and the other European countries. The camps had only one purpose: for Jews to be brought to the extermination camps to be killed. They would arrive at the camp, usually after having spent several days in transit, with little or no food or water, and within a few hours of reaching the camp, they would all be dead. Goering planned the war. His only goal was murdering Jews, not the sovereignty of Germany. He set in motion the greatest world war in history, involving over 30 countries and 75 million fatalities. You must remember, as plenipotentiary of the 4-year plan, he created the infrastructure for all of this, for 75 million deaths. And don't mistake that number for a statistic. That number includes mothers, fathers, sons, daughters, brothers, sisters, children, friends, and more. Hermann Goering killed loved ones. He killed 6 million Jews. His orders through his leadership had the repercussion of a world war where the Allies were obligated to enter because Goering's undeniable, irrefutable guilt of war crimes and crimes against humanity.
Thank you, prosecution. The defense may now stay their opening.
Hermann Goering's actions during and before the war were executed solely to improve and protect the lives of the German people. From 1933 to 1945, every action he took was for the good of Germany. Whether it was improving the economy and creating millions of jobs for struggling Germans, or defending his country by locking up verified enemies of the state, Goering did everything for the good of Germany. Before the war, Goering was the plenipotentiary of the 4-year plan, tasked with strengthening and uplifting the German economy. His job was not to create industrial munitions manufacturing or build new factories for the military, but instead merely to, quote, safeguard the independent basis of the life and economy of the German people, quote, as any good civil servant would do. Goering succeeded in his task and brought 3 million jobs to the German people, which uplifted the struggling economy and helped bring pride back to Germany. While boosting the German economy with agriculture and manufacturing productivity ultimately helped Germany succeed during wartime, in reality, Goering's role within the economic preparations for the war were solely peaceful and legal. The catalyst for these economic changes and reforms was due to the Treaty of Versailles, which was problematic at best and dangerous and evil at worst. Since its creation marking the end of the First World War, it was meant to be a temporary solution to pacify and stabilize the region. However, it was used as a long-standing, legally binding document which only served to starve the German economy and its people. Some may argue the treaty was legally binding, and Goering's renunciation of it illegal. However, Germany had both legal and logical precedent to do so. The treaty contained explicit language regarding the disarmament of Germany, which they complied with. It claimed that Germany must disarm after the First World War, quote, in order to set a precedent for general disarmament, quote. Germany fulfilled its requirements to do so. However, the Allied forces never honored their agreement for this general or global disarmament in the name of their pacifistic democratic ideals. Dr. Stammer reasoned in his affidavit that, quote, as they did not disarm, Germany was no longer bound by the pact according to the general principles of law, and she was justified in renouncing her obligations. This interpretation agrees with the view which has been expressed by French as well as by English statesmen, end quote. The other side did not comply with their agreement and did not follow through in actually disarming themselves and the world, despite Germany leading the way. As it was not being upheld by the opposing party, Germany had legal precedent to defer and recover from the treaty. Another reason Germany was justified in deviating from the Treaty of Versailles was because it was internationally recognized as broken and oppressive. As testified by Dr. Stammer in his affidavit, quote, the Treaty of Versailles was not only felt by the German people to be a bitter injustice. There were numerous voices, even in foreign countries, that called the treaty exceedingly unfair for Germany, quote. Many of these foreign doubters were American, and one proposed the Dawes Plan in 1924. The plan put in place a system which sent loans to the U.S., from the U.S. to Germany to attempt to rebuild the decimated economy. The United States' acknowledgement of the enormous long-term flaws of the treaty show it was impossible for Germany to succeed and grow underneath it. Goering's choice to renounce the treaty and revitalize his country's economy to help his people, instead of obliging to a treaty which was recognized by all parties as oppressive and broken. The prosecution may argue that Goering's position as a leader of the military is illegal, but Germany is a sovereign nation and thus entitled to a military. Oxford Dictionary defines sovereignty as, quote, the power of a state to do everything necessary to govern itself, including making war and peace, quote. And as a sovereign nation, Germany has a right to do just that. Germany has the explicit right to hold and operate a military, and specifically in this case, an air force, despite the oppressive Treaty of Versailles, which infringed on this basic right for a country. Some may argue that Germany was allowed a military, just not an air force. However, for a sovereign nation to be able to defend itself adequately in the technological era of the 1940s, an air force is not just helpful, but vital to defend itself. Goering's role as the commander-in-chief of the Air Force of this sovereign nation was entirely legal. The duty of the leader of any branch of the military is to be prepared for war at any time, so Goering should do the same for his own branch. The notion that Goering's status as a military leader is illegal and wrong infringes on Germany's basic rights to defend itself, regardless of what the broken treaty says. If Goering's position as a military leader is illegal, then so is every other. The communists and Jewish Germans were a real and serious threat, not just within Germany, but in various powerful nations around the globe. The German Jews and communists represent the same threat to the German people during the Weimar and Nazi Germany era. In America, the people saw the threat of communism to their lives and had their government put practices in place to neutralize anyone linked with a dangerous party and ideology. These practices removed any threats of the enemy communists within high-ranking positions in the US. These acts were carried out in much of the same way in Germany. The people saw the threat of communists and Jews and sought after a path to neutralize their enemy, as any public servant defending his state would do. American Jim Crow laws set the precedent for the race laws, which defended against German Jews. The United States ruled using these laws, which attempted to protect those within the country. These laws were not illegal within the US or by any international law, which there was very little precedent for in or before the 1940s. The same applies for the race laws of Nazi Germany. While serving as the commander-in-chief of the German Air Force, Goering was unaware of the mistreatment of enemy airmen who had been shot down and captured in Germany. And when he was informed, he was directly against the actions of his men. Despite his status as commander-in-chief, he was opposed to the way the enemy was treated. In a testimony regarding this mistreatment of prisoners of war, specifically the captured pilots shot down over Germany, Dr. Stammer testified that Goering said, quote, once they have been shot down, they are our comrades. Quote, this is not indicative of someone who would allow enemy pilots or any prisoners of war to be mistreated or even tortured within his knowledge. The abuse of prisoners of war was due to the men serving beneath him, unbeknownst to Goering. Goering created the first concentration camps in 1934 to defend against the already identified, verifiable inside enemies of the state. Goering testified that, quote, these arrests were in accordance with reasons of state security and state necessity. It was a question of removing a danger, quote. Goering knew that to protect the German people from dangerous groups like the communists, he would have to, quote, deal ruthlessly with these enemies of the state. These arrests were not a malicious act, but an attempt to preserve the security of the state. Every government and nation incarcerates and tries the known enemies of the state, and Germany's case is no different. After the creation of the camps for defensive purposes, Goering testified that he was not aware of the heinous acts which were being committed beneath him. Once he found out, he did not, quote, wish that any act of brutality should be committed against those in the camps, quote. Further testament to Goering's wishes to see everyone treated fairly was an instance in which a political rival of Goering, who was being held in a camp, was beaten. Goering reacted swiftly by shutting down the camp, prosecuting those who did wrong within the camp, and supporting his rival's wife financially. All of this evidence is proof that Goering is not someone who condoned the mistreatment of anyone, even the enemies of the state. There were also many camps which were not directed or authorized under the authority of Goering. Goering was not responsible for the individual day-to-day actions of the men working in the concentration camps in SA. He was openly and on the record against the mistreatment of enemy civilians. While Goering was against the mistreatment of even his enemies, the entire basis of this charge is hypocritical, as the United States imprisoned under harsh and inhumane conditions hundreds of thousands of innocent Japanese Americans during World War II under the Executive Order 9066 for the purpose of national security. Roosevelt wrote that, quote, "The successful prosecution of the war requires every possible protection against espionage and against sabotage to national defense material," quote. Like Germany, the United States was trying to protect their citizens while conducting a, quote, "investigation of alleged acts of sabotage or the duty regarding regulations for the conduct and control of alien enemies," quote. The exact same wording Roosevelt used in this executive order can be repeated to defend Goering's actions. Both men were simply defending their nation from its enemies, attempting to do what was best for their people. If Roosevelt's justification for the U.S. internment camps applies to the Americans, then it applies to Goering and Germans as well. If not, this is an unfair and hypocritical trial, guilty of the victors seeking false justice through sham legal processes merely designed to portray themselves as the heroes of the story. Goering's job as Prussian Prime Minister led him to create the secret state police in 1933 for the, quote, "prosecution of crimes and offenses against the state," quote. This was by no means illegal in any form. Governmental intelligence and police agencies designed to protect the citizens of their nation exist everywhere. The secret state police were no different from the FBI when they were created and under Goering's command, which was only for less than 2 years. When Himmler took control in 1934, there were rampant crimes committed within the agency. These continued leading up to and during the war. All crimes commonly accounted occurred after the assumption of power by Himmler, not under Goering's rule. While Goering was the commander of the secret state police, they were solely utilized to protect Germany and its people from dangerous enemies of the state. Some may argue that Goering is guilty of waging war for the purpose of claiming territory, but Germany's case is no different than any other instance of colonialism. The very concept of Lebensraum is identical to the colonialism the United States practiced while expanding westward, or the French or British practice while seizing control of much of the rest of the world. These countries needed room to expand and sought the control of new territories. They believed that the land was rightfully theirs for the taking and was willing to displace whoever was there at the current time. The Americans did so with the Native Americans who were brutally forced out of their land, so the Americans could realize the concept of manifest destiny. The German practices of Lebensraum were only different in 2 facets. They did not force the removal and relocation of its pre-existing inhabitants, and they were reclaiming land stripped by the Treaty of Versailles, which was already denounced due to its flaws. Ultimately, Goering's role in Germany's reclamation of territory is no different, if not improved, than that of any other military leader from any colonial nation. Once again, if the Allied nations can justify their procurement of land, the same justification should apply to Germany. There are many instances of the Allied forces practicing the same charges the defendant is indicted on. The United States detonated 2 atomic weapons on 2 Japanese cities. The American justification was Japan would surrender and thus preserve hundreds of thousands, if not millions, of Allied and Japanese lives. If the U.S. can have military justification to eliminate Hiroshima and Nagasaki and the over 300,000 innocent lives within it, because it was what was best for their country, Germany should be allowed to justify their bombings too. Ultimately, the question of hypocrisy and double standards within these legal proceedings are absolutely critical. If any Allied nation can justify any of their actions because it was ultimately what was best for their country, German defendants like Mr. Goering should be able to do so as well. Justice, like beauty, is in the eye of the beholder, and if the panel is seeking true justice, they must decide with no biases towards their own nation. Thank you.
Thank you, defense. The defendant may now make his statement.
I have loved this country, and I will continue to love this country for the rest of my life. All I ever wanted to do is to make sure she thrived. The prosecution has me all wrong. My main goal throughout my entire career has been to ensure Germany's prosperity. At the tender age of 17, I started my life's work in the German military. Despite the Air Force being dissolved after World War I did not give up on my mission. I never gave up on the country I loved. I continued to want the best for Germany, so I ran for a position in the Reichstag. With all my hard work and campaigning, I won 2 elections and became the Speaker of the Reichstag, fairly. The prosecution paints me as a man who only had my own interest in mind, who only did for himself or his party, yet all I am is a simple patriot. My passion, all my goals, all my intentions were for Germany's benefit. My goal with the 4-year plan was to bring Germany out of her economic shambles due to the horrendous Treaty of Versailles. Yes, I broke promises within the treaty, but how was I supposed to sit there and allow my home to become dependent on other countries like the United States? Even with the assistance of other nations, we were not where we needed to be. No other country was going to help us like we could help ourselves. My 4-year plan created 3 million German jobs, something the prosecution wants to disregard. They forget that under the Treaty of Versailles, we had 6 million Germans unemployed. After my 4-year plan and other Nazi programs, it was down to 1. The prosecution will argue that my 4-year plan was built to start the Second World War, which is simply unfounded. Creating a stable Germany also meant that we would be ready for war, if war should come. Becoming ready for war does not mean I wanted war. In fact, I never did. Every country in history has had preparations for war at any time. For example, look at France and the United Kingdom. Both countries were avidly opposed to war, just like I was. But guess what they still had? Strong militaries. Ensuring preparedness is something that sovereign nations do. It has nothing to do with violence or aggression. Therefore, I also had to establish the Luftwaffe. Every other nation in the world was allowed to have an air force. Why not Germany? The Treaty of Versailles took away Germany's right to protect itself. The treaty made Germany defenseless and dependent on other countries if we needed protection. As a sovereign state, Germany had a right to protect itself. So although my actions were illegal, morally, I still stand by them. I was a soldier in the First War, a pilot, and for a nation on the other side of Europe to tell me I could no longer have a job, that I could no longer fight for what I love, how was I supposed to feel, knowing that there was a ban on my very existence? Well, that's what the Treaty of Versailles told me and all the other patriots who flew. With my Luftwaffe, I restored hope and dignity to millions of Germans who lost pride after so much was taken away from them. Yet, whenever the prosecution wants to bring up the Luftwaffe, Gestapo, and the Prussian police department, they equate my actions to aggression and genocide. Let's make one thing clear. I am completely disgusted, and I condemn these murders to the utmost and cannot understand them in the least. I have never ordered the murder of a mass group or individual, nor have I signed a decree tolerating such horrific behavior. Although I have to take responsibility for every bullet shot by Prussian police, this does not mean I ordered them to kill. Has everyone in my police force always behaved or listened to me? No. The prosecution has yet to show me any evidence commanding a murder of any kind. I am but a simple servant to Germany. That's all I am and all I ever was. Throughout my years of commanding and legislating, I have never strayed away from my promises. All I've ever wanted to do is to ensure that my home would prosper and thrive. That's all I have ever wanted.
Thank you, defendant. The direct examination may now begin.
How did the Treaty of Versailles affect German life before and during the war?
Before the war, As I was a pilot, I was able to fly freely. And personally, I have never felt more free than when I was in the air. But after that got taken away, all my friends who were pilots, we could do nothing. After the treaty, our economy was in shambles. Life was just not, it was not the same. I even had to leave my own country to become a pilot because they would not let me fly in my home country. Can you even believe that?
Why did Germany create the Air Force?
We had none before. The horrendous Treaty of Versailles forbid it. It was oppressive. How were we supposed to defend ourselves? All other countries had more technology than we would have if there was no Air Force. How were we ever going to defend ourselves if we didn't even have something that all other nations could have? It's not even the lack of people, it's the lack of resources that we had. I had to reestablish it to protect ourselves. I knew so many pilots who were gravely affected by the Treaty of Versailles. We can no longer fight for the country we loved, and I have always loved this country.
What were the goals of the 4-year plan?
My goals with the 4-year plan was to ensure that the German economy would be safe, because under the Treaty of Versailles, we had lost so many jobs, so many people were out of work, and so many people were out of work and nothing felt the same. I had to create it because people in Germany were starving under the Treaty of Versailles. We had no resources. So I had to create the 4-year plan to ensure that we could protect ourselves, that no German would starve, that people would live a great life, a good German life.
Did you wish to harm any enemy prisoners you captured?
No, I never wished harm on any person. Not a Jew, not a communist, no one. Although I did take over other territories during my time as the head commander of the Luftwaffe, I never wanted to do harm on anyone. I made sure to stay within the Treaty of Hague. I wanted to make sure everyone was safe. I even shut down concentration camps because I felt like the soldiers over it were being too vile and horrendous people. I wanted to ensure that even if you were my enemy, that you would be safe in Germany, although you wouldn't be in society. I never wished harm on a single person.
If you didn't harm them, who did?
I would have to say one of the worst decisions that I personally have made was to put Himmler as in charge of the Gestapo. I didn't hurt them, my soldiers hurt them, but when Himmler was a part of the Gestapo, he ordered the soldiers to do many horrific things that I personally cannot stand by. So they did that and Himmler commanded it. I have no idea who. I made sure that my soldiers treated everyone with a certain amount of dignity. It was not on me.
What problems did communists and Jews cause within Germany?
If you remember the fire at the Reichstag, if you remember those times, the communists set fire to our very own democracy. The Reichstag, Germany's most important building, was set on fire, set ablaze by a Dutch communist. They were trying to end democracy as we knew it. I could no longer stand to see other people trying to take away from our nation. I could not let us become communists. Communists are a threat in every single country in the world. The biggest threat that they posed was they were trying to end our democracy. If they were peaceful, like my party initially was, then I would have no problem with them being there. But because they set fire to our own democracy, there was no way I personally could allow them to just roam free after they set fire to the Reichstag in 1934.
No further questions, Your Honor.
Thank you, defense. The cross-examination may now begin.
Defendant, you have taken responsibility for a lot of things that most people wouldn't willingly want to associate themselves with. In document R410, which is a conference that you directed, you say that this responsibility rests heavily on me. You may believe me. In regards to being fully prepared for an incoming war. So yes or no, defendant, by saying this, were you holding yourself totally accountable for Germany's entire preparedness for war?
As I've mentioned before, there's a difference between preparedness and there's a difference between wanting to initiate a war. In December of 1936, I said I never wanted war. I never wanted war. So I, yes, made us stable for a war, but that's
your
because
entire job as plenipotentiary of the four-year plan was to prepare the German economy for aggressive war. Do you agree?
No, I don't agree with that.
How can you argue that your job wasn't to prepare the German economy for war when you're quoted saying that you see it as your task to, within 4 years, to put the entire economy in a state of readiness for war? In the same document in EC 408.
I created the 4-year plan to help Germany. Germany was in such an utter state of disrepair. We had 6 million unemployed. I could not stand here and let other countries walk over us. We were so dependent on other people. We didn't need to be ready for a war. I never wanted war. We just needed to be ready to be stable again. Our job got closed from 6 million to 1 million.
So you're telling me that in the same document, I quote you saying that you are convinced that an 80, 85% or 90% chance exists that a greater disaster will occur anyhow, and that we shall have to fight a great battle of which I am not afraid.
There's a difference. Things were escalating across the entire world. If you
were quoted saying that you are sure, you're 90% sure that a war will occur.
Yes, I was 90% sure a war would occur, but that has nothing to do with my 4-year plan. I was to safeguard food supply. People were starving. I could not let that happen. My job was to ensure that we would have protection. If a war were to start, that's why we needed even more protection. But I was just doing my job.
You also commanded the German Air Force against the Treaty of Versailles, correct? Was this to protect food resources?
It was. I needed to establish it because I was a soldier myself. And the Treaty of Versailles, as I told you, it reduced our populations to starvation. How was I going to allow people to starve? And how was I going to allow people to be out of work? I remember, if you eliminate an entire Air Force, imagine where those jobs are going to. I had people working in factories. That's what I was doing. Not to start wars, or the Luftwaffe is not a part of that. It was just to establish something that was already there.
Then why are you quoted saying on how your intentions to build the Luftwaffe, that you intend to build a Luftwaffe so, excuse me, let me find the quote. That you intend to create a Luftwaffe, which, if the hour should strike, shall burst upon the foe like a chorus of revenge. The enemy must have a feeling of already being lost before even having fought.
That's something that every single nation wants. That is something that single nation wants to have. Britain, when they built up their air force, they wanted to annihilate me and my allies. The US did that when they bombed Hiroshima.
Say, defendant, that you made initiating World War II possible for the Nazi Party, and I also contend that you were the one who tried to bring a close to it. Defendant, do you recall a letter that you wrote on July 31st, 1941 to the Chief of the Security Police? Just a yes or no, please. It's copied in document 710 PS.
Yes.
In this letter, you ordered the recipient for, and I quote, a complete solution of the Jewish question in the German sphere of influence in Europe. Are you aware that you demanded for the execution of all Jews in this letter?
That is not what I said in my letter. That is not what I said. I never wanted death to all Jews.
You say that, but did you do anything when you noticed what was actually happening was not what you
Objection.
ordered?
I did not,
I
Himmler.
ask the court to please let the defendant speak and fully defend himself.
I did not. Those were in the words of Himmler, I mean. I did not do that. I, yes, said there needs to be a solution. Let me finish. There needs to be a solution to the question, but that was not really part of my question. After Kristallnacht, time is up.
You say that, but did you do anything when you noticed that what was actually happening was not what you had ordered? Because I don't see a written and signed letter from you ordering to stop any killing.
Can you find a letter of me saying that I encourage killing? Because I know you cannot find that.
In the letter that I just presented to you.
I'm sorry, prosecution, your time is up. The tribunal will now be asking some questions.
Mr. Goering, you were at the Geneva Conventions, correct?
Correct.
What was your role in the final solution?
My role, honestly, I did not really have a plan in the final solution. I was, of course, there, but I personally was not really a huge fan of it. I believe that Jews should belong in our society. I had many Jewish friends. Jews that have actually saved my life before during the beer hall putsch. What I did for the Jewish question is I ensured that businesses would be turned over, because after Kristallnacht, Jewish businesses were in utter disrepair. So I had them sign it over to the state, because no good German would hurt German businesses. So that's what I've done. I actually took Jews out of Germany because I thought it was getting too hard because of Himmler's actions. I did not really play a part in the Jewish question. I actually even opposed the Nuremberg race laws.
Did you plan to return the Jewish property seized by the German state to the Jews once the war was finished?
Well, another thing is, with the fine, I was going to have to keep their businesses and their property, sadly, because there was a huge fine. We were actually paying, to repair the properties. So that was not my intention, no.
When exactly did you become aware that Himmler was treating prisoners of war and German Jews poorly?
I became aware. I was really not aware of this for the longest time, but I truly became aware of this when I saw his horrific work with the secret police. I actually had to go against Himmler and take my friends the Ballens out, because Himmler was trying to take them out. But I could not go. That was not my part in the military. I was no longer a part of that. I would say my worst decision was giving Himmler to become the head of the secret police. But I found out about it, but at that point there was nothing I could do. Himmler was way too powerful for me.
I have a question. You mentioned the Luftwaffe was necessary to defend Germany. However, the bombing on Liverpool was not out of defense, but more an attack. What are your thoughts on that?
I had to defend myself. They were trying to start war. It was not, I was trying to defend myself. Yes, I might have bombed Liverpool, but really it was to show Germany's strength. I could no longer say, I could not say that like my real intentions why. I just knew that the UK was going to be a threat to us because they've already threatened us before with war. And yeah.
Follow up. So was it not because Liverpool happened to be one of the biggest ports of the UK?
That's correct.
If you believed, or you just stated that you believe that Britain was going to become a threat again because they already were a threat, then what is your opinion of the Neville Chamberlain's attempt to appease Germany and stop war in the 1930s?
I actually was pro that. I really did not want a war. In December of 1936, I said that I didn't want a war. I would actually sign the treaties, but still, they were unfair to Germany. So I could not go along with them. But if we could have never had war, that would have been my best intention.
Who do you believe initiated World War II?
I believed everyone who created this Treaty of Versailles started the World War II because they left Germany in this place of starvation, of job loss, of hyperinflation. They're the ones who started it without trying to help us bring back our economy. So really, I think those allied nations who started the Treaty of Versailles are the ones to blame for the World War II.
However, what do you say to the claim that your violation of that very treaty is what initiated the war?
My violation did not do that. See, the Allied countries still had arms. So therefore, they had already violated the disarmament after that. So technically, if you want to use that case, they still initiated the Second World War. I did not do that.
Do you believe had you not violated the Treaty of Versailles, the war may have been prevented and millions of lives could have been saved?
No, I do not believe that because war to me seemed inevitable. The Treaty of Versailles had done so much to harm Germany. Something had to happen. Although I did not want war, I realized that we needed to protect ourselves because the Treaty of Versailles had already done so much harm to Germany. There was nothing else to do. Even if we didn't retaliate, someone could have tried to attack us even because we were in such a loss that other countries could have taken us over as well. So that would have caused another war. But no one was trying to help us. So that's why I was involved in the Luftwaffe.
If no one was trying to help you, then what do you think of the Dawes Act cited by your defense, where the U.S. sent loans to Germany?
They were loans, but like I said before, they were simply not enough. We, yes, got a little bit more money, but we were not where we needed to be. I grew up in the German Republic. I saw how amazing things were, but yet there was so much heartache. They just provided money, but they didn't send any protection, and yet it was not enough. They gave us money, but they weren't trying to truly build up our economy. I was trying to do that.
The prosecution may now close.
Your Honor, the positions he held, found in document 2836-PS, undeniably show Hermann Goering's guilt of conspiracy, crimes against humanity, crimes against peace, and war crimes. He created the infrastructure for World War II. The blood of 7 million lives lost is on Hermann Goering's hand. He is responsible, and it isn't hypocritical to blame a man who murdered and try to say it is identical to colonialism. His irrefutable guilt is unjustifiable. Given all the evidence, document 2324-PS, where he confesses for his murderous ways. Document 3441-PS, where he violates the Treaty of Versailles by creating the Luftwaffe. Document EC-317, where he cuts off resources in other European countries. Document 1956-PS, where Goering was pronounced the leader of the secret state police and in which the SS created concentration camps. Document 710-PS, where Goering writes a letter to Hydra initiating the final solution. Our defendant claims that Hitler was responsible, but why send this letter? Think, do you believe it is justifiable to group every Jew as a communist? Our defendant now claims that war was inedible, but previously did not say so. There was not a single example of, through the sovereignty of any country, the murder of 75 million people, besides Hermann Goering's orders to set in motion this war. I urge you to apply the law and convict Hermann Goering. And the question you must ask yourself is, will you be responsible for letting the man accountable for the biggest genocide in world history walk away? He is undeniably the mastermind behind the greatest world war. And if you let him leave this courthouse today, unconvicted, think what our future as human beings looks like. He is a murderer. Think of the future of humanity. Think of the lives lost.
Thank you, prosecution. The defense may now close.
Everything Goering did was for the good of Germany, whether it was creating new jobs for millions of people, making the difficult decisions of war, or helping even his worst enemies against violence. Goering's economic policy was not an attempt to engage in aggressive war, but only to be a good civil servant to the people of Germany, and to create a better economy and thus life for the German people. Germans were starving on the streets, and all he wanted to do was make it better for them. Goering's actions were not made to hurt any of the Allied countries until they started attacking back. The comparison to colonialism is that Germany did not start the war. They simply tried to engage in new territories, and the allies of those countries attacked Germany. His intentions were not to hurt anyone outside the rules of war, as demonstrated by Goering's testimony, in which he stated that he helped people escape from Germany when he knew that Himmler was too far gone in his power with the secret state police. Goering controlled the secret state police for a brief period of less than 2 years. During this time, he did not conduct anything unlawful, and the agency operated like any other intelligence agency. The crimes everyone is talking about now happened after Himmler took control, which Goering was explicitly against. The murders conducted were not up to Goering. It was not his choice to have these murders committed. It was the choice of other powerful representatives within the Nazi government. He did not have the power to stop it at that moment. If America can justify interning hundreds of thousands of Japanese citizens for the good of their country, Germany should be able to do so for the same reason. They were both deemed threats to their nations, and ultimately were made the decision to intern and incarcerate. Ultimately, Hermann Goering did what was best for his country, like anyone trying to defend themselves. In the final minutes of this case, we must decide whether Mr. Goering's actions were for the good of his country, and whether the other countries involved in the World War II had any fault in starting World War II as well. I do not believe that Germany was entirely at fault for starting World War II and the 75 million deaths that followed. It is naive to think that there was only one party responsible for World War II, as the United States, Britain, France, and the Soviet Union, along with countless other nations, contributed to these deaths as well. Thank you.
Thank you, defense. The court will now adjourn and return at 2 for the case of Karl Dönitz.
Okay, audience members, please just give us a minute. This is normally where you just sit and watch this changeover happen live. So justices, if you were on that panel, you know to go to the deliberation room, and everybody else, we're going to get started. Ms. Dorsey, you want to wait till 2 o'clock to get started with Dönitz? Attorneys who are in here for the Dönitz case, make sure you change your name to either prosecuting attorney or defense attorney. Same for justices. Remember to either be Chief Justice or Justice. Okay, so Ms. Dorr definitely did go open the deliberations room. So we're going to go ahead with the schedule as planned, just in case there are any people that just were coming in for the Dönitz case. They're planning on arriving at 2 o'clock. So panelists and audience members, students and families, take a couple-minute break, and we'll get started right at 2 o'clock. Court is back in session.
The IMT versus Karl Dönitz case may begin. The prosecution may now present their opening statements.
Your Honors, Judge Mendoza-Pena, Judge Kloskop, and Judge Mendelson of the International Military Tribune, to my colleagues seated here today in front of you and to the real parties of interest in this case, good afternoon. Our names are Kieran Garapati and Eli Alterman, and we represent the prosecution in the case concerning the defendant, Karl Dönitz. This court has reviewed many documents, and the matters discussed are significant and should not be overlooked. But at its core, the case is very simple. Karl Dönitz is guilty of charges of conspiracy, crimes against peace, and war crimes. The actions he continuously committed were evil, inhumane, unjust, and led to the deaths of many innocent people.
Your Honors, Karl Dönitz is most definitely guilty of conspiracy. Throughout his time serving in the German military, Dönitz has been a great advocate for the indoctrination of soldiers to a point at which men would commit heinous acts under the belief that it was for the German good. As shown in document D640, Dönitz asserted that the whole quote, the whole of the officer corps must be so indoctrinated that it feels itself corresponsible for the National Socialist state in its entirety. That's from D640. There are multiple other documents and speeches which share a similar message, brainwashing troops to condone and commit horrid Nazi violations. On top of being a great advocate for this, Karl Dönitz was briefed on Operation Fallweis, the invasion of Poland, and he was briefed on countless military operations in Denmark and Norway. While the defense may argue that being merely briefed on something bad is not a crime, I would like to bring up that after being briefed, Dönitz issued orders on the matter, showing his active compliance. This puts Dönitz in a position of conspiracy. These orders are shown in document C-172. A different example of a signed order by Dönitz is document C-151. It is a direct order by Dönitz to occupy Norway and Denmark simultaneously in a surprise and undercover attack. Those orders were later carried out and caused great damage and unrest. It should also be known that Dönitz had held a high position among the Nazi ranks. Almost any words that came out of his mouth had an impact on how the German forces operated. The importance of Dönitz in Germany even further shows his guilt in the charges of conspiracy. Additionally, Karl Dönitz is guilty of multiple counts of crimes against peace. During his time serving the Nazi Party, Karl Dönitz has actively helped wage wars across Europe in violation of the Kellogg-Briand Pact, along with constructing a U-boat arm, which is in direct violation of the Treaty of Versailles, which explicitly states in Article 181 that there shall be no submarines in the German Navy. Also, after succeeding Hitler as the Führer of Germany, the defendant stated that soldiers should, quote, fight obediently, hard, and faithfully, unquote. This speech by Dönitz is transcribed in document D650. To provide further context for this quote, Adolf Hitler had recently passed and the German forces were in a clear losing position. Instead of ordering a retreat or throwing a white flag, Dönitz urged his troops to keep fighting. This resulted in many casualties that could have been easily avoided had he not continued the fight. While this cannot be considered as a crime against peace, there was already great unrest. This does, however, show Dönitz's attitude towards the war and how it reflected on what he did in the beginning. By being an active participant and leader in the war later on, there is no telling how far the defendant could have actually gone with planning, perhaps even off the record. On top of the count of conspiracy stated previously, Dönitz has violated the Kellogg-Briand Pact by waging wars in Poland, Norway, Denmark, and England. On top of the previously cited surprise attack on Denmark and Norway, document C-172 is a set of instructions and orders written and signed by Dönitz, which involve the use of U-boats in Operation Fallweis. These orders call for, quote, destroying the Polish armed forces by a surprise and lightning operation, unquote. That's from C-172. This scope of signed orders points to clear guilt of multiple counts of crimes against peace, as Dönitz had taken an active role in numerous important military operations.
Your Honors, Dönitz is also guilty of war crimes. From the beginning of the war, as commander of submarines for the German Navy, he ordered assault on both enemy and neutral ships, resulting in the destruction of these ships and causing the death of many innocent men, and thus breaking the Naval Protocol of 1936, which reaffirmed the rules of submarine warfare laid down in the London Naval Agreement of 1930. In the first year of the war, as seen in document D641A, the British reported 253 neutral ships sunk, 112 illegal attacks against Allied merchant vessels, 79 of which were ruthlessly torpedoed without warning. 2 instances were delineated out by the British. Quote, on the 30th of September, 1939, came the first sinking of a neutral ship by a submarine without warning and with loss of life. This was the Danish ship Vendia. The submarine fired 2 shots and shortly after torpedoed the ship. The torpedo was fired when the master had already signaled that he would submit to the submarine's orders, and before there had been an opportunity to abandon the ship. End quote. That is from document D641A. Later, quote, on the 12th November, the Norwegian Arne Kode was torpedoed without any warning at all. The master and 4 of the crew lost their lives, and the remainder were picked up after many hours in open boats, end quote. Document D641A. As we can see, Karl Dönitz and his men cynically disregarded international treaties and sunk ships without any regard for the safety or life of the crew. In particular, Dönitz violated the Naval Protocol of 1936, to which Germany acceded to, concerning the articles on submarine warfare and the destruction of merchant and civilian ships. Under this treaty, submarines must surface and make themselves visible to the ship they want to attack. They must signal to the ship and ask for surrender. However, if the ship does not surrender, then the submarine is permitted to fire at the ship, but only when in waters where the coast is near and weather conditions are favorable. Dönitz broke this clear set of rules multiple more times. In the sinking of Noreen Mary, James McAllister, a witness of the sinking, recalled in his affidavit that the U-boat had fired 2 torpedoes at the ship without warning. Luckily, both of these missed. However, about an hour later, he said, quote, and without any warning, the U-boat immediately opened fire on the ship with a machine gun, end quote, from document D645, resulting in the death of all but 4 crewmates. Nazi submarines continued to repeatedly violate the treaty and wage aggressive warfare in disregard of the Naval Protocol of 1936. Throughout the next year of the war, the British grew increasingly concerned about the actions that German U-boats were committing for, quote, at least 16 ships that were torpedoed outside the limits of the war zone, end quote, from document D641B. The city of Benares was sunk on September 17, 1940, and is just one of many ships sunk outside the war zone. The ship was torpedoed without warning, resulting in at least 59 people dead from this attack, many of whom were children due to the bad weather and distance from the coast they were. Quote, the point to be emphasized from this attack is not the unusual brutality, but rather such that these results are inevitable when a belligerent disregards rules of sea warfare, as the Germans have done, end quote, document D641B. As we can see, Dönitz clearly waged illegal warfare many times, resulting in the deaths of many innocent people. On multiple occasions, Dönitz ordered his men to annihilate the opponent. During the sinking of Vendia, that, quote, the master of the neutral ship had already signaled that he would submit to the submarine's order, unquote, document D641A. Yet 2 torpedoes were still fired at the ship, signaling that Dönitz and the U-boats wanted to do more than just have prisoners of war. Later, in 1943, Karl Dönitz ordered his men to sink rescue ships as, quote, their sinking is of great value, end quote, document D663. Altogether, this violates Article 2 of the Geneva Convention, which lays out that prisoners of war must, quote, must at all times be humanely treated and protected, unquote, something which Dönitz did not provide. That is an excerpt from the Geneva Convention of July 27, 1929, relative to the treatment of prisoners of war, Article 2. Another example of when Dönitz disregarded the rules of war and human life occurred during the sinking of the Antonico. Even after the ship was sunk and surviving civilians were clearly prisoners of war, the ship continued to, quote, ruthlessly machine gun the defenseless sailors, end quote, document D647. It is clear to see that Dönitz's intention was to annihilate anyone in his quest for victory, even if they were innocent civilians. Although the defense may argue that Dönitz was never recorded giving an order to fire at survivors, he most definitely would have stopped the U-boats from doing so if he truly believed it was wrong and immoral, as he was in control of all U-boat soldiers. Again, Dönitz defied international law and respect for humanity in his secret standing order number 154, which he personally signed, in which he ordered his soldiers to not pick up survivors and take them with you. Do not worry about the merchant ship's boat. Weather conditions and distance from land play no part. Have a care for only your own ship and strive to attain your next success as soon as possible. We must be harsh in this war, end quote, document D642. This order from the first year of the war stands in direct violation of the rights that a prisoner of war has, and clearly the prisoners of war are not being protected, as Dönitz ordered the survivors of sunken ships to not be cared for and instead just left behind. Dönitz words this order such that he intends for Nazi soldiers to destroy survivors by limiting their chance of survival. Later, in 1942, Dönitz also issued another similar order, the Laconia Order. This once again stated that, quote, no attempt of any kind must be made at rescuing members of ships sunk, end quote, from document D630, no matter how bad the conditions are. Dönitz even says that he wants to conduct warfare by, quote, annihilating enemy ships and their crews, end quote, from document D630. Later, when Dönitz hears of Scott, the officer on the Laconia, caring for Italians, Brits, and Poles by giving all shipwrecked persons a, quote, hot meal and drinks, clothes, and bandages were necessary, end quote, document D630. Dönitz replies to this by telling Scott that the ship is only, quote, detailed to rescue Italian allies and not for the rescue of English and Poles, end quote, document D630. Once again, Dönitz shows that he does not protect prisoners of war. As seen multiple times from the start of the war in 1939, Dönitz does not care for prisoners of war and does not treat them humanely, which is in violation of the Geneva Convention. Lastly, Dönitz also proposed during a conference in 1944 that, quote, 12,000 concentration camp prisoners will be employed in shipyards as additional labor, end quote, document C195. This was later accepted and put into action. Dönitz not only knew how bad prisoners of war were treated, but recommended additional labor. Dönitz should bear his full share of responsibility for his treatment of prisoners of war, as he clearly violated the Geneva Convention, saying that all prisoners of war must be humanely treated. Your Honors, from the beginning of the war, Karl Dönitz has ordered for merchant ships, both Allied and neutral, to be sunk illegally without warning. When danger zones were announced by the German government, sinking continued. Both inside and outside of these zones, there is no regard taken for the crews or passengers of the sunken ships. We can clearly see that U-boat warfare under Dönitz was being conducted with no regard to the rules of international warfare that Germany signed off on or the requirements of humanity.
Therefore, Your Honors, we, the prosecution, request that the defendant, Karl Dönitz, be charged with multiple counts of conspiracy, crimes against peace, and war crimes.
Thank you. The defense may now present their opening statements.
The defendant, Karl Dönitz, is a military man. He has been in the military since he was a teenager, and he was a military man regardless of the party in control of the government. His life is devoted to the Navy, not politics. He was a member of the German Navy, 29 years before World War II started. He had no political ambitions. Instead, his life was devoted to his country and the well-being of its soldiers and civilians. In fact, he was not a member of the Nazi Party until 1944, an action based on necessity, not desire. Furthermore, Dönitz's patriotism and strong camaraderie to those in the Navy are the guiding principles of his actions throughout his whole career. This information, while it may seem irrelevant to the case, is actually very important context that is vital to many aspects of this trial. Before I proceed with the speech, I would like to state the conclusion outright. Karl Dönitz should be found not guilty on all charges. The reasons for this conclusion will be outlined through the remainder of the speech. With this context in mind, I will address the charge of conspiracy first. I will take the time to define conspiracy, as I am certain that the prosecution will make claims about the defendant throughout the trial that are not relevant to the charge of conspiracy for the prosecution thereof. Conspiracy can be defined as the planning of crime, such as war crimes and crimes against humanity. Dönitz was a military man, not one who had influence of the party. Furthermore, he was not in attendance at any of the meetings where conspiracy was committed. Let me repeat that. He was not in attendance at any of the meetings where conspiracy was committed. These meetings are such as the Hausbach Memorandum, where aggressive wars were formed, and the Wannsee Conference, where plans to commit crimes against humanity were formed. The defendant also did not have any leadership role in the Navy until after the planning phases of the war. This alone makes it entirely evident that Dönitz is not guilty of conspiracy. As how could a military man with strictly tactical roles who is absent from all conspiratorial meetings and was not even in a position to be invited to such meetings be guilty of a crime? But to further my point, I'll reference a piece of evidence that makes it hard to see how the defendant could have committed such crimes. The document with the number Dönitz 91 is an affidavit from Dr. Joachim Rudolphi, a legal advisor in the Department of the German Navy Supreme Command. This document proves how Dönitz resisted all attempts to execute Hitler's plan to take naval personnel under the control of the Nazi Party. This runs in direct contradiction with the prosecution's narrative about Dönitz. It shows how he actively resisted Hitler and the politicization of the Navy. This demonstrates how Dönitz was not a political man, but in fact, the opposite. Also, how could it be true both that Dönitz actively resisted Hitler's attempts to do something as small as take control of the Navy, while also actively planning war crimes and crimes against humanity? It is clear this cannot be the case. To summarize, Dönitz was a naval man, not one who had control over the planning of the atrocities of World War II. He was absent from all meetings where conspiracy was planned. Lastly, his documented actions cannot coexist with that of a man who committed conspiracy. Therefore, the tribunal should find Karl Dönitz not guilty of conspiracy. Next, I will address the charge of crimes against peace. Crimes against peace are defined as the planning or waging of aggressive war. It is clear that the defendant did not plan aggressive war. As I described before, he was not at any of the meetings where it was planned, such as the Hausbach Memorandum. Furthermore, it was never Dönitz's role to plan actions, only to execute them. In other words, his role was strictly tactical, and this is plainly clear throughout all the evidence. It is also clear that Dönitz did not wage war, both by his absence at meetings in addition to his rank at the time. He was not in high command of the Navy until 1944. This is far after the plans for aggressive war were solidified. The evidence was clear. He was not the one who started the war or planned the war. Out of love for his country, Germany, he tried to protect German soldiers and civilians. This is true throughout the whole war. He protected his sailors, German soldiers, and his country by defending it after it involved himself in aggressive war. It should be expected that Dönitz should have done his duty to protect German soldiers after they involved themselves in war. German soldiers required support from the Navy, and they would surely be slaughtered if that support were not provided. In some ways, it could be argued that it would have been a crime for Dönitz to not support his countries and soldiers. Protecting your country and its soldiers and civilians after they involve themselves in war is nowhere near remotely close to planning and starting of aggressive war. That is unambiguously true. This would surely suffice to acquit the defendant of all crimes against peace. But I would like to note that I am confident the prosecution will attempt to use evidence that is irrelevant to this charge for the prosecution thereof, as well as make claims that are far beyond the reach of what evidence shows. I will make sure to discuss such instances in my closing statement, but I also urge the justices to be incredibly attentive and aware of their use of these tactics. For the reasons I outlined, the tribunal should find Karl Dönitz not guilty of all crimes against peace. Next, I will address the charge of war crimes. Before I proceed, I would like to address the conditions of war. War causes one to be constantly making decisions of high importance. This leads to decision fatigue. It's subsequently something called the fog of war. This is a strong psychological effect that makes it harder to make decisions. Consequently, it is unfair to view wartime actions without acknowledging the fog of war. Next is the context of war. In war, the statement, "There are no right and wrong decisions, only compromises," could not be more true. Trying to win a war while protecting your civilians, soldiers, and your country, while also interpreting international law and trying to follow treaties to the best of your ability is extremely difficult, if not impossible. Therefore, I remind the justices to look at this case with the context of war in mind, as it is required to give the defendant a fair trial. I would like to provide context to some of the important events and orders that are relevant to this charge. First, Dönitz never ordered the sinking of rescue ships, and no such order was ever implemented. This is demonstrated by 4 U-boat officers' testimonies that can be found in the documents with the numbers Dönitz 13 and Dönitz 29. I will state just one of the many excerpts that support this claim. This is a quote from Hans Fruman, a U-boat officer. This is from Dönitz 29. "I have never heard him say that shipwrecked enemy sailors ought to be attacked. Such an utterance from Admiral Dönitz would have been unthinkable." Next, Dönitz did not order his men to take no prisoners of war. He simply stated that they are not required to take prisoners of war. He never insinuated that they shouldn't. In fact, he was just trying to get across the point that can be summed up by a quote from from the same testimony from Hans Fruman. This is from Dönitz 29. Quote, "He also emphasized that in rescue efforts, it is important to remember the realities of today's warfare. In good conscience, it is not possible to expose the U-boats to extreme danger during rescue of shipwrecked enemies. There is ample evidence of many attempts being made to save shipwrecked enemies, even when endangering U-boats." These can be found in the documents Dönitz 13 and Dönitz 29. The same pattern repeats through a multitude of the prosecution's claims. While I do not have the time in the statement to address them all, the prosecution has consistently pushed the use of evidence past the point that is responsible. Therefore, I ask when ruling that you be careful when dealing with the prosecution's claims and attempt to verify them all. I will also attempt to address all instances that the prosecution has stretched evidence too far in my closing statement. Now, I'll introduce the most vital piece of evidence to this charge, and the one that gives much needed context to the defendant's actions. Document Dönitz 100 contains the testimony of Fleet Admiral Nimitz, who is the United States Navy's Chief of Naval Operations, a similar position to what Dönitz held in the German Navy. The key takeaways from this document are as follows. 1. The U.S. expanded its theaters of operations, or in other words, the limits of its war zone. It was customary for the U.S. to attack ships without warning. 3. The U.S. submarines did not rescue enemy survivors if undue additional hazard to the submarine resulted. 4. Nimitz validly justified these actions with the fact that the circumstances of the war and the actions of the enemy made these actions necessary. Before I proceed with the analysis of this document, I want to make it clear what I am not saying. I am not saying that because the US did the same thing as Germany, it makes what Germany did not illegal. What I am saying is that the circumstances of the war justified US actions, so too did it justify Germany's actions. Just as Nimitz worried about the safety of his ships and his crew, so did Dönitz. Just as Nimitz had to be afraid that if they took too many shipwreck crew on their boats, there could be a mutiny, so did Dönitz. Just as Nimitz knew that the war necessitated attacking into conditions where rescue wasn't possible, so did Dönitz. Just as Nimitz knew the war necessitated expanding theaters of operations, so did Dönitz. The list could continue for a while, but for the sake of time, I will continue. I am using the Nimitz interrogatory simply as an example of the conditions of war universally necessitated certain actions that the writers of various international laws and treaties could not anticipate. This is very important, so I'm going to repeat that again. I'm using the Nimitz interrogatory simply as an example that the conditions of war universally necessitated certain actions that the writers of various international laws and treaties could not anticipate. These men's actions are a clear product of necessity, not blatant disregard for international law. These men both tried to engage in war as civilly as possible while acknowledging the realities of war. Erlich Heiss's testimony from Dönitz 13 demonstrates this well. As he said, that they engaged in war as honorably as possible. Overall, 1, it's important to keep in mind the context of the fog of war when dealing with situations involving war. 2, the prosecution consistently exaggerated takeaways from the evidence beyond what is reasonable. 3, Dönitz's actions merely boil down to him acting as humanely as possible while keeping in mind the realities of war. 4, Admiral Nimitz plainly admitted to acting in the same way as Dönitz. He justified his actions as they were necessitated by the war. Dönitz's actions were necessitated by the same conditions. For these reasons, the tribunal should find Karl Dönitz not guilty of war crimes. In conclusion, Dönitz was a man who has devoted his life to the Navy to best help his country, not a man who involved himself in politics. He was never in charge of planning, and he acted in a way to protect Germany, its soldiers, and civilians throughout the whole war. He acted as humanely as possible while keeping in mind the realities of war and within the fog of war. Finally, his actions were necessitated by the context of war. It is clear that Dönitz found himself in a series of tough situations and made the best of a horrible situation. Not a man that the prosecution will attempt to paint him today. And that, alongside the arguments presented today, are why the tribunal must find Karl Dönitz not guilty of all charges. Thank you for your time.
Thank you. The defendant may now give their statement.
I am Karl Dönitz, and I am here today because my vast naval talents, work ethic, and patriotism led me to rise through the ranks in the German Navy and to find myself in a position of power inside of a government I did not support. When I was growing up, I moved frequently between small towns inside of Germany with a hardworking father who had the burden of raising his 2 sons after my mother died. I was raised in a very patriotic climate, and this led me to join the German Imperial Navy when I was 19 years old. I enjoyed being in the Navy and I was good at it. I was quickly promoted, giving me validation that left me looking to become an officer. Eventually, I was assigned a position as the second lieutenant on the ship, the SMS Breslau, just before World War I. During the war, the ship that I was on was transferred to the Ottoman Navy. Being a professional sailor, I did my duty and served the Ottoman Empire, because that is what I am, a professional who does his duty. This duty was strained when I was put in charge of an airfield in the Dardanelles. My true passion was being in the Navy, so I quickly became bored with being on land, and 6 months later, put in a request to be transferred back to sea. Once the transfer went through, I was assigned a position as a watch officer aboard the U-boat UB-39. I quickly realized that as much as I loved the Navy, I loved U-boats even more. It was as commander of UB-68 that my boat sank after having technological issues. I spent the rest of the war in a British prisoner of war camp. Needless to say, the time I spent in World War I gave me plenty of insight into the German Navy and how U-boats worked. In July of 1919, I returned to my home in Germany. At this point in time, Germany as a whole was distraught and felt wronged due to the Treaty of Versailles and its vast limitations on our country. I'd received a phone call from the Navy's headquarters in Kiel, Germany, asking if I would like to continue my service in the Navy. I responded by asking, "Do you think that we shall soon have U-boats again?" Even though Germany was not permitted to have them, I was responded to with assurance that there would be German U-boats the following summer. In September of 1934, I was promoted to captain of the cruiser ship Emden, a boat that had year-long excursions in order to train newer sailors. However, my position as captain on the ship did not last long, because after returning to Germany, Grand Admiral Raeder, a man with whom I frequently disagreed, gave me the order to build a new U-boat flotilla. If I declined this position, it would have been filled with ease and I would have lost respect inside of my own Navy. I was commander of the new Vettigen flotilla, which only consisted of 3 submarines, not enough for an aggressive war, but enough to rebuild the pride of the German Navy. As the commander, I was ordered to talk about the Nazi ideology, which I did not wholly align with. This was an order I could not have realistically ignored. At the beginning of World War II, I was promoted to Commodore, and then later that same year, I was promoted to Rear Admiral and commander of the U-boats, still required to take orders from Grand Admiral Raeder and the many other superiors that I had. When the German Navy was defeated in the Barents Sea in 1943, Hitler became furious and he demanded Grand Admiral Raeder retire. I was chosen to replace the Grand Admiral because of my success as a naval officer, not my loyalty to the Nazi Party. However, after a year of serving as the Grand Admiral, I was made to join the Nazi Party a little over a year ago. I only joined because if I had not, I would have faced repercussions, not because I believed in it. In 1941, Hitler signed a secret decree saying that if he were to die, the person in charge of the German Air Force, Hermann Goering, was to succeed him as the leader of the German state. However, when Hitler was hiding in his bunker, he received a telegram from Goering, which was extremely egotistic and questioned whether Hitler was actually a good leader. This, once again, infuriated Hitler, and out of an act of impulsivity, he decided that I would succeed him when he died, much to my surprise. Hitler killed himself on April 30th, 1945, and I took power as the leader of the German state. It all moved very fast, and I honestly was not prepared enough to become the new leader. I spent my extremely short amount of time in that position attempting to get German soldiers back home. I sincerely believe that the jobs that I had in World War II were due to my luck, my naval talent, and motivation. From age 19 to 54, I served in the German Navy, showing my patriotism by serving for the better years of my life because I loved my country, not the Nazi Party, and I never planned on being placed in powerful positions in a government that had such a terrible ideology. Thank you for listening.
Thank you. The direct examination may begin.
How many years over your lifetime did you spend in the navies?
I spent 35 years in the navies.
Over the course of those years, how many times were you promoted?
I was promoted 13 different times.
Please describe the extent of which your political involvement in Germany extended.
I rarely let politics influence my life, which was a very uncommon thing in Germany, especially during World War II. I did not fully align with the Nazi Party throughout its history, and because of that, I did not join the Nazi Party until 1944. In 1944, I joined the Nazi Party because if I had not, I would have been punished and likely not had the same opportunities at the end of my career.
How did you become the leader of the German state?
I became the leader out of the German, I became the leader of the German state out of luck more than anything else. As I briefly mentioned in my plea, for 4 years, I was not supposed to succeed Hitler. However, Hermann Goering, the man Hitler intended to precede him, sent him the challenging and self-centered telegram that I mentioned in my plea, which made him act impulsively. And then he, out of rage and, to my surprise, decided that I would succeed him.
Did you attend the Hossbach Memorandum meeting where aggressive wars were planned?
No, I did not. And I was not in a position where it would ever be remotely considered for me to receive an invitation to this meeting or any meeting of a similar nature.
Did you attend the Wannsee Conference where the mass murder of Jews across Europe was planned?
Again, I did not, and I would not have realistically been able to attend that meeting.
What were your priorities throughout your naval career?
My priorities were all surrounding the betterment of Germany, German citizens, and people as a whole. Additionally, I believed in my personal ability inside of the Navy to help the German people and the world as a whole. So early in my career, I tried to quickly rise ranks in the German Navy.
What was your reason for getting involved in World War II?
The reason for my involvement in World War II was in order to best use my expertise as a naval officer in order to protect Germany's well-being after it had already involved itself in a war. As a man whose life was spent in the Navy protecting Germany, I felt an obligation to continue that life mission. To be clear, I did not want to have a war. Instead, I wanted to keep Germany safe. But Germany involved itself in the war, and it seemed necessary for me to use my talent to protect it once again.
To what extent were your wartime actions necessitated by the conditions of World War II?
All of the actions I made were compromises. The conditions of war left no clear decisions, as they always do. Everything had to be done impulsively. In this way, many of my actions can only be products of a wartime situation where there were no clear decisions. The choices I made during this war needed to be done. This war necessitated my impulsive actions, and I stand behind that sentiment fully.
What was the intended meaning of the extract from BDU War Diary, September 1942, the document with the number D630?
The intended meaning was that U-boats are not required to rescue shipwrecked crew in the case that harm to the ship would result. This was in response to the air attack on the U-boat Hartenstein while it was engaged in rescue effort in 1942. I always held the position that even in war, the rules of humanity still applied. I wanted to make it clear that U-boats rescued whenever possible or whenever it was feasible, and that this order was made out of necessity to maintain the safety of German crews while also maintaining the rescue efforts as much as possible. I wanted to make it clear to my crew that they should continue rescue efforts, meanwhile acknowledging the context of war. Countless documented cases of rescue efforts by German U-boats exist throughout the war, and these make the intentions of this order clear.
How do you feel about the way the prosecution presented you in your opening statement, and do you have any objections to the way they presented you?
I don't believe that they presented me accurately, as that is their job in this trial. But if you look at document C-118 in their own book, it literally says the Fuhrer ordered the following: 1, attacks on merchant vessels. And throughout their argument, they stated that I was the main cause of these, but you have to take everything with a grain of salt, because For the majority of the war, I was not in a powerful position at all. And even at the times when I was in charge of the Navy, I still had countless superiors over me. And my freedoms inside of my own naval tactics were very limited. So for a lot of the times that the prosecution will claim that I ordered things, while I might have while I might have said, do this, I did not create the order that I was told to give that order by my many superiors. And that is a common thing that happened throughout World War II.
That will conclude the direct examination.
Thank you. The cross-examination may now begin.
Hello. I would like to begin this cross-examination by asking you, what were your roles during the German Navy and later the German nation during the course of World War II?
You're asking about my responsibilities?
No, your ranks and roles in the German Navy.
All right. I started out as during World War II, I ranked up. I gained a lot of ranks, very rapidly. And in those, I started out as a lieutenant, I believe. And then towards the end of the war, I was in charge of, I got promoted to a position where I was in charge of U-boats specifically. And then I was in charge of the German Navy as a whole, but I frequently focused on tactics surrounding the U-boats specifically at that position, which led to a lot of the rest of the Navy not appreciating that. And then for a very, very, very brief amount of time, I was the leader of the German state, only for around 20 days.
May you briefly, please state the actual titles of the roles which you had?
Yes, I can.
Briefly, please.
Yes. So you're talking about World War II specifically?
Yes, World War II.
I was a lieutenant. Then I only have the German name, so forgive me if my translation is off, but I was lieutenant, and then I was captain, and then I was captain of another ship, and then I was promoted to commodore, and then admiral, and then a position in which I was in control of all the German U-boats, and then Grand Admiral, where I was in position or in charge of the Navy.
Thank you.
So, were you aware of the secret standing order number 154, which you signed, and it was ordered in 1939?
Is this in your evidence book?
Yes, it is in my evidence book.
Do you mind if I pull it up to reference it?
Sure. But were you aware of the order that you placed?
You're talking about 154?
Document D642, secret standing order number 154.
I was aware of it, but like I said previously, this order was not by my creation, and even if I did not issue this order, my superiors would have made countless other people issue this order. So my role in this was completely insignificant.
So did this order, which you signed, mistreat prisoners of war and violate their rights at the time of war?
My intention was not for it to do that, and I could not control every single individual person in the German Navy, which there were a plethora of. However, it might have contributed to mistreatment of prisoners of war, excuse me.
All right. So at the time of which you signed this order, were you aware that the order may lead to deaths of innocent people? I never thought that the good German naval troops were going to use it to that extent, and that, as I said before, that was not my intention of signing this order, but I guess I could have seen it as a possibility. Yeah. However, the German troops were under your command as your commander of the U-boats, correct?
Yes, but my command was over every single person, so it is unrealistic to assume that I'm able to control every individual person in that group.
Right. So Were you aware of the Laconia order that you gave?
I do not recall.
All right. On document D630, the Laconia order that you gave states that, or rather, I should say, it is an extract from your BDU war diary that states no attempt of any kind must be made at rescuing members of ships sunk, and this includes picking up persons in the water and putting them in lifeboats. So,
well, yes, I did issue this order. If you look at your own evidence book, as I said earlier, C-118, Hitler, quote, the Fuhrer ordered the following: 1, attacks on merchant vessels. So it was out of my control.
however, that does not relate to this order.
Is this
This is a top secret order from your personal war diary.
Okay, well, if you look at in your own document book, once again, document D641B, quote, Hitler proclaimed that every ship without convoy is going to be torpedoed.
But this regards rescuing members of ships sunk.
Right, but I genuinely think that this specific order is irrelevant based on Hitler and my many superior stance on merchant shipping and just destruction of other ships in general, because based on their stance, as you can see, they were not very forgiving, and it was not at all their own priority to pick up prisoners of war.
So were you aware that this order to not pick up prisoners of war was a violation of the Geneva Convention?
Yes, but yeah.
And this is from your personal war diary, correct?
Correct.
All right. And then did you advocate for the indoctrination of German soldiers under your command?
I was ordered to advocate, and if you think about Nazism as a whole, you cannot realistically have imagined one single insignificant naval leader to stand against Nazism as a whole.
Prosecution time is up. I will now yield to the justices on the IMT versus Dönitz case to ask any clarifying questions.
I have a question for the defendant. What were your intentions in signing the orders and documents stated by prosecution?
Like every single document that they stated?
Yes.
My intentions were not necessarily as what was written on the documents explicitly, because it was a responsibility of my own position that I had to sign those documents, as I've said previously. So my intention in signing those documents was maintaining my position in the Navy as a whole, but not specifically whatever every single individual document that they've stated is, if that makes sense.
A question for the defense. In your brief, you said that Dönitz himself saved survivors of other vessels, but that was in the year 1941. Could you just clear up when the Laconia order was issued?
Let me recall that. When was I think it was in 1944. But there, within my evidence of, you find in Dönitz 13, there are a multitude of cases in which survivors' ships were saved, and that was after the date 1944. I want to make that clear, because that's just one example that I gave, but it happened before and after, and I want to make it clear that after that order, it did not cease all rescue of survivors. All that it did was that it essentially allowed for ships to take into account their own safety, and because after the ships had been air attacked, U-boats had been air attacked while trying to save survivors. So this order was a result of that. After they had been air attacked, that they were gonna make sure that they were not getting bombed while they were trying to save, essentially.
Objection, the Laconia order was in September 1942.
Another question for the defendant, just as clarification, your reasoning for signing documents and for executing your orders from higher authority is solely just because you wanted to keep your position in the Navy?
If I had not signed and executed those orders, that is correct. I would not have my position in the Navy. So my intention, and if I like attempted to ignore those orders, then they would have happened anyway. So my signing in them or execution of them is completely irrelevant. But yes, my intention was so I could remain in the Navy.
And a clarifying question for the defendant. You said that you weren't interested in politics, and could you have possibly given the position of Führer to someone else when you took power?
No, Hitler specifically decided that he wrote down in his, I forget what it's called, I think it's a will, that it was going to be Hermann Goering, as I said. But then he impulsively said it was me, and knowing Hitler, he would not have been willing to, change that decision.
If any other justices would like to ask a question, please do so now, but we are running out of time.
I have a question for the defendant. Can you please clarify your whole situation with the U-boat and what you had to do with it?
From early in my career, I started with U-boats towards the end of World War I, and I had a specialty in them. My tactics surrounding U-boats specifically were very good, which was the main reason that I rose ranks throughout both wars. And then I was given a position to be in control of specifically the U-boats before being which is a division of the Navy, before being in charge of the entire Navy.
Can you please clarify more on what you had to do with the U-boats in World War II?
In early of World War II, I was like physically on U-boats, and I was commanding them and lieutenants on them. And then I used my naval tactics as strategies for World War II when in control of specifically the U-boats. And then when I was in charge of the entire Navy, as I said, I was in charge of the entire Navy, but my tactics mainly were surrounding the U-boat specifically, because that is what I did best.
Got it. Thanks.
Prosecution may now present their closing statements.
So to begin my closing statement, I would like to point to the defense's argument that many orders which Dönitz has signed off, or many decisions he has made, are okay because there was fatigue, and it's difficult to make such decisions during wartime. And I would like to say that first off, was it not his role to make such decisions? Is that not what he should have been preparing for? A decision is a decision, and you cannot argue that. What he did was wrong, and backing up by saying that it was a difficult decision is just not okay, because he did at the end of the day sign it off. In World War I, when a U-boat which Karl Dönitz was on sank, he was saved by a British ship. But in World War II, when a merchant ship was sunk unlawfully, by the way, by a U-boat, Dönitz ordered for, first off, the crews to be gunned down and for them not to be rescued in general. How could that not be the same case? You also cannot compare his actions to Nimitz, as the two situations were very, very different. with Nimitz, the Japanese merchants were known to be hostile, and there have been cases of hostility from the Japanese ships to the American ships, which were trying to rescue them. In this case, they were not. And I again point back to before in World War I, where he was saved. He could have very easily made the very same decision. Additionally, the defense has claimed that Dönitz has not wanted to participate in politics that much, and he did not align himself with the Nazi Party. Well, then I point to you to multiple speeches of him going for the indoctrination of soldiers, which I have talked about in the opening statement. These documents would be D443, which he said, quote, "It is necessary for him to train the soldier uniformly, comprehensively, that he may be adjusted ideologically to our Germany. The soldier, therefore, must stand with his whole weight behind the state." Also document D640, where Dönitz has said, quote, "The whole of the officer corps must be so indoctrinated that it feels itself corresponsible for the National Socialist state in its entirety." Is that not showing clear support for the Nazi Party, along with showing his politics and his clear stance on upholding the Nazi Party? These falsities are stated multiple times throughout the case, and there's no telling what else Dönitz could have lied about, especially off the record. And the hostility of Japanese soldiers, I'm sorry, I forgot to say this, would be in a document in the defense's ebook. That would be question 11, or Q11 of Dönitz 100, I believe. Wait, let me check. Yes, Dönitz 100, question 11, in which they said that Japanese soldiers were hostile, which changes things completely. And Dönitz claimed to have wanted peace. However, when he was Führer, he urged his troops to fight. This was shown in document D650, where he actively told troops to fight hard, when, like I said in my opening statement, he could have very, very easily told them to have a retreat and to resign. Also, if the defendant was so keen on not wanting to sign these orders, was so against them, then could he not have just stepped down? He could have avoided these positions, and instead he actively climbed the ranks of the German Navy, which just put him into a position where he signed more and more orders. These orders were both detrimental to the Germans, and they promoted unrest. Especially, they promoted unrest in neutral nations such as Norway and Denmark. A lot of this can be found in our briefs and in the ebooks. The best thing to do is to read through the evidence and let it truly speak for itself, because what he did in those moments is clearly wrong. And the defense's main argument here is that it was a tough decision during wartime. But at the end of the day, that decision still stood. And those neutral seamen were now dead because they were not rescued by the German U-boats. You cannot take that back. I ask the justices to not acquit Dönitz of the crimes which he is being charged for, as what he did is clearly wrong, and he is clearly at fault in this case, as he signed this off. You could say, or like the defense said, that Dönitz could not, or he had to sign them. There was no other option. The option was to step down, and he chose not to, and he chose to climb.
The defense may now present their closing statements.
The prosecution has just presented a series of straw men, okay? And essentially, he is representing my case incorrectly. He has stated that Dönitz could have just stepped down and that what he did was clearly wrong. My defense for that is that his actions were necessitated by the war. I believe that his actions without a wartime period are inexcusable. But in war, these actions were necessary to keep the safety of Germany. Next, it is clear that the prosecution did not find clear evidence to prosecute Dönitz on many of the charges. This is due to their showering of evidence. During their opening statement, I was not able to keep up with the amount of evidence that they gave. Let me ask you, if the prosecution had clear evidence of the crimes Dönitz committed, why wouldn't they take the time to explain each piece of evidence and give each quote? Clearly they have not. So they have decided that because they could not find clear evidence, instead they would like to shower me with so much evidence that me and the defendant are not able to respond to correctly. I will take the time to try to respond to as many of the false claims that I have caught, but I do not think that I have the time to catch them all because there were so many and there were so many documents that were given. First off, the indoctrination of soldiers. This is in no way conspiracy. Conspiracy is planning to commit other crimes. This is totally irrelevant information, and it should not be used to prosecute for conspiracy, as that is not a crime to express your opinion within a speech. Okay. Next, document C663 did not order the sinking of rescue ships. In fact, it was just another order reiterating what I said, that in some cases, ships were not to be rescued due to the circumstances. And I just want to continue with my argument so that it's clear, because right now I am concerned that the prosecution has presented my argument incorrectly and has showered so much information that it's hard to see what is really going on. So first off, Dönitz spent his whole life protecting his country with his naval prowess. He was never political. In fact, he fought Hitler to stop the politicization of the Navy. This can be found in Dönitz 91. He was not a member of the Nazi Party until 1944. He did this because he knew it required him to continue helping his country. Most other military officials in Nazi Germany gained this through political power, but not Dönitz. Dönitz's patriotism and strong camaraderie to those in the Navy are the guiding principles to his actions throughout his career. Next, for conspiracy, Dönitz was not at any conspiratorial meeting. For example, the Hossbach Memorandum and the Wannsee Conference. Dönitz was not in a position to be invited to any of these conspiratorial meetings. And Dönitz's documented actions don't line up with someone who committed conspiracy. And Dönitz, next for the crimes against peace, Dönitz did not plan war, and he wasn't at the Hossbach Memorandum. Dönitz did not wage war, as he did not start it. He merely protected German soldiers and civilians. He did this to protect his country that is loved so dearly. He had been doing this for 29 years before World War II. And Dönitz engaged in war as civilly as possible while considering the circumstances. The prosecution has constantly exaggerated Dönitz's actions and makes claims that are far beyond what the evidence suggests. The circumstances of the war universally necessitated actions taken both by Nimitz and Dönitz. They acted both in the same way in response to the same circumstances. So next, I want to bring up the point about hostility. The hostility of the Japanese merchantmen. Well, there was hostility as well. If you look in document Dönitz 13, you can find reports of you can find reports that people are talking about there being a mutiny if they take too many men on board, and of course there were hostility. This wasn't a war. It would be ridiculous to suggest otherwise. Next, I want to talk about the psychological effect of fog of war. The prosecution has painted my argument there falsely. They have made it seem as if I'm trying to say he shouldn't be held responsible for his actions due to the fog of war. That was an additional piece upon that I said needed to be taken into account. I never said that nullified Dönitz's actions. In fact, even without the fog of war, I think it will be plainly clear that Dönitz was not guilty of war crimes, as all of his actions were necessitated by the circumstances of war, and they were all the same as Nimitz's actions, which were also necessitated by the same things. Also, the prosecution has continued to paint this case unfairly, and I don't think their tactics have been fair throughout this trial or before, with the showering of evidence so that we couldn't keep up with it, as well as painting my argument falsely in order to that will conclude my statement.
The court will now adjourn until tomorrow.
Wow. They were good.
Yes, great job, everybody. We might still have some attendees in here, but you can just turn your videos back on, and we'll cut this from the final video.